In this video, we're going to talk about my first impression here after reading the Copa v. Wright Injunction, which came out yesterday. All right, so stay tuned to the end. We'll break it down here. We're going to do an X space today, so look for that. I'll upload it on YouTube here in a recap as well. So, all right, so 64 pages of reading and of the judgment. Read the whole thing, and it was quite elucidating in the way of educational standards in the way of an injunction. Now, an injunction is, as it says in the order, the judgment, it's an equitable remedy. It's actually an old English common law remedy that stems back from the nature of the king of England. So back in like the medieval times, back in the day of the feudal system and the feudal era, the judgment would basically be, the injunction would be entered usually by a writ, where somebody would petition the king and ask the king for his blessing and his decree to make someone do something or stop them from doing something. And so it's evolved now as it's talked now into the court, into the case here, into the modern era, and it's allowed by statute in the English under their UK statutes, and it's also allowed under the common law, where someone can petition for an injunction to tell someone to stop doing something or basically to do something or stop doing from something. So it's like what's called a mandamus injunction, where make you do something, or a prohibition, which is prevent you from doing something. So in this case here for Dr. Wright, the court decided that some of the relief was rather erroneous, rather too broad. And in fact, it looks like it was somehow McCormick was asking for relief in this case. And he was asking for like a global gag order against all jurisdictions from Wright saying it was Satoshi. So the court did deny that. That was, I think that was issue 4 and 5, relief 4 and 5. But they did order Dr. Wright to put up on his website and on his Twitter feed that it says legal notice, the court's order saying that I'm not Satoshi Nakamoto, and he cites the order from the court and the injunction, and that has to stay up there for 3 months. So they also referred the case over to the criminal court and prosecution, and they also referred Stephen Matthews there as well. Now, okay, so that all sounds like, depending on what your side, which side of the legal freaking landscape in the Perry Mason courtroom side that you're rooting for, that sounds like very good side for the lazy-eyed maxis. They probably love it. Now, the BSV people on the other side of the fence, they probably think this is horrible, this is bad news. Well, let me just give you kind of the perspective for the BSV people as to why, there could be something really good at the end of the tunnel here on what's going on in the strategy. Now, one of the interesting things is that the court, Justice Mehl, he wrote in the appeal in the injunction that Dr. Wright had never petitioned the court to appeal. Now, apparently in the UK, there's a rule that allows you to petition the court, and then the court will then cite the grounds. So, in a rather unusual maneuver here. Now, this is think this through. So the court's could allow him to petition the court for appeal, that direct court, and then inside of this ruling, then the judge would write in there, well, here are the possible grounds for appeal. Dr. Wright decided not to do that. Then yesterday, right after the judgment comes out, he goes on I seen it on his Twitter feed on a separate little Twitter account that he has, and then also on a Slack channel that he's going to appeal. That's going to be August 5th, which is the 20th day. So he's definitely appealing. That was what his words were. Now, he didn't petition the court, though, so therefore he's got to petition the appellate court. All right, so it's rather interesting, why wouldn't he ask the lower court for a right to appeal? Does he not want to hear what Justice Mehl has to say for the grounds are for some sort of a distraction, some sort of a strategy, or I don't know. But in a rather interesting maneuver, he's going to petition the appellate court and exercise his right on appeal, which will be on the 20th day on the 5th of August. That will start. And so, everything's going to be basically ruled on at that point. Now, I'll put my link to the video at the end here that you can watch, that where I show the what I believe to be the reversible error on appeal grounds and the exact line in the judgment. Now, when an appeal is going in, it's only about what's in the record, and it has to be pointed into the judgment. So, like I'm pointing here where we raised this objection, and then the court overruled the objection here, and he stated in this particular case that Ager Hansen is not a bad actor, and that's another lie by Dr. Wright. So that right there is the grounds I would focus in on. Definitely for the reversible error on appeal, because if you have one bad actor, just one bad actor in a case of forgery and fraud, where there's been where the court has found that Dr. Wright has committed forgery and fraud on a monumental scale, like a scale that the court's never seen. I mean, this is like a unprecedented forgeries and frauds. That's what the court has found. So if that's the case, and there is a bad actor, okay, that is now found to have been interfering with the case by another judgment, that's enough right there to say, well, whoa, stop, foul on the court. That's enough to say, this other guy interfered here. Wait a second. We can't pin all this on this guy, Dr. Wright. He might as well be, well, in the way they're finding him guilty, but it's a judgment. He might as well be, this might as well be a mistrial. That'd probably be what would happen, some sort of a mistrial. I don't know if it would go back and say all of a sudden he's Satoshi. Maybe they will. That's my prediction, is it will go back on appeal, though, on those grounds. And also the Madden report shouldn't have got in the first place. I know that people disagree with that, but the problem is that Wright had put in very weak rebuttal evidence from his experts. Okay, but here's the key. He's gonna claim on appeal there was interference from Ager Hansen, and Ager Hansen was running his appeal strategy. So I'm sorry, Ager Hansen was running his Copa case. He was running the Copa case. Remember how Ager Hansen had the wig in the classroom, and he was saying, let's have a pretend mock trial here, and we'll pretend we're in court right now. Apparently, that was against the rules. That was a sign that Ager Hansen was willing to put Dr. Wright under the fire, make him break the rules of the court by having a pretend mock trial, I guess. That was something Ager Hansen had orchestrated at that time when he first was managing the case. So that's something to be mindful of, and I think that the rights attorneys will definitely bring that up on appeal, the interference with Ager Hansen and the inability of Dr. Wright to present proper rebuttal evidence on it from experts, because those experts he had already hired, they'd already been working on it. They put in weak rebuttals. By that point, they're going to trial. It's hard to gather another expert, I guess, and regroup at that point. Plus, the court would have to grant additional time on that, and they just went forward. So, there's the grounds. I think that we'll see how it plays out. But he's definitely going to be appealing on it, and I'm going to be doing a show today talking about the judgment itself, and we'll do a long space on it right now, and then we'll go ahead and post a space in my video to follow, so you can check it out. All right, so. Be sure to hit the like button, thumbs up, the little one, all right? Share the video, leave a comment, make a comment on X if you see it there, and retweet it, quote me in a tweet, hit me up on there if you like, and be sure to look up, because I will see you at the top. This is Gavin Mehl, Gavin Gregory. Later, dude.